Well, the most strange, surreal, bizarre experience I've had as a legal services lawyer was the Mount Holly litigation, particularly the last few years of it. It's one of the most heartbreaking cases that I've ever been involved in. When I first came to Mount Holly Gardens in 2003, I came there because a client of ours had received a notice that she needed to go to a meeting. This was a client of the Mount Holly office. We had represented her on other matters. She'd gotten this mysterious letter saying she needed to come to a meeting to talk to relocation specialists about relocating from her house. And she didn't know what it was about and why she had gotten this. So we did some digging, and we discovered that in 2002, Mount Holly had designated the Mount Holly Gardens neighborhood as an area in redevelopment, which is a euphemistic way of saying blighted. The Gardens at that time had 327 homes. It was built in the 1950s, this sort of like garden apartment type, townhouse type development of blocks of houses, 8 to 10 houses per row. It was built as housing for the military coming back from World War II. And there were actually people still living there who had moved there in the 50s after the war. It was where the vast majority of Mount Holly's African American and Latino population lived. And it was predominantly low income. So Mount Holly in 2002, well, actually, we found out later, back in 2000, Mount Holly concocted this idea that they were going to designate the area as blighted and demolish it. And they started building up a vacancy rate. So when they acquired a home through foreclosure, instead of turning it over and reselling it, they would sit on it and acquire more and more houses so that they could up the vacancy rate. In 2002, the vacancy rate was somewhere around 16%. When they passed the redevelopment plan, a few people went to the hearing. We learned this from reading the transcript and said, what does this mean? Are you going to take our homes by eminent domain? And they were assured, oh, no. We want to improve your neighborhood. We're going to be doing these surveys to see what you want to have happen in your neighborhood. We want to make sure that your needs are addressed and that we make your neighborhood a better place to be. A year later, they came out with this redevelopment plan, which called for the entire demolition of the neighborhood and relocating everybody out of it. And the plan didn't provide for any replacement housing to be built anywhere. They just said, we're going to give people the relocation assistance to which they're entitled under the law, plus some extra, more than what the law requires, and then we're going to expect them to find other homes wherever. So once our client found out about this and talked to a few more people, they organized a meeting. We came, Ken was there, Lynn Devine was there, a few other people from the Mount Holly office came, and we told the community what this redevelopment plan meant. And of course, they were horrified and they thought it was terrible and they wanted us to oppose it. So we went through the process of trying to oppose this redevelopment plan. And no matter how eloquently residents spoke out about it and how much they said, this home is my only asset, a lot of people had moved from neighborhoods that they considered much scarier, much more crime-ridden, much worse schools, and they had come to Mount Holly thinking it was more quiet, it was more peaceful. Meanwhile, the township was saying, no, it's ridden with drugs and crime, and it's horrible, and it's a blight on our city, and we want to get rid of it. So the council adopted this redevelopment plan, and we challenged it in court. At that time, we had a whole string of claims, some based on state law, that there were technical problems with how they did the study and the plan. There was a claim that the neighborhood wasn't really blighted, that they hadn't proved blight. There was claims that we had a sort of a reverse Mount Laurel, what we called Mount Laurel is about exclusionary zoning. We called it exclusionary redevelopment. If you can't do exclusionary zoning to keep people out from coming in, how can you do exclusionary redevelopment to actually throw out people who are already there? We included fair housing and law against discrimination, disparate impact claims, because clearly this was having a negative impact on a community that was predominantly a community of color. So we had a host of claims. The judge was very unsympathetic to our civil rights constitutional claims. He sort of shoved them aside, didn't want to hear them, said he'd deal with the state claims first. We litigated that, And he found that the plan was valid and that the blight designation was valid. And he said that our other claims were not ripe for adjudication because at this point, even though we had a plan that said the entire neighborhood was going to be demolished, we didn't know how the plan was going to be implemented. We didn't know if people really were going to be able to find other housing or whether they weren't. So our claims are basically premature. We appealed that to the appellate division and they upheld that ruling. We appealed that up to the New Jersey Supreme Court and the Supreme Court didn't take the case. So by this point, 5 years had gone by. And I'm pretty sure that's right, 2008. And by that time, half of the people in the neighborhood had been basically decided to leave. They didn't see much hope to the litigation. It was going nowhere. The township was pressuring them. The township started doing all these things that were really destructive, and this is part of what makes the case heartbreaking. Really, really destructive to the neighborhood to weaken the morale of the people there and force them out. They did SWAT team exercises without any warning to the community. So all of a sudden at 5 a.m, firefighters would be putting out a fire in an abandoned house, or police SWAT teams would be descending in helicopters. They started demolishing vacant buildings because they said they were a hazard. And we went to court several times trying to stop. We went to court in state court and federal court to try to stop them from doing the demolitions. We couldn't get an order stopping them from doing demolitions. First, they demolished N units. Then they decided they would come in and bulldoze their way through in between two occupied houses. They caused an incredible amount of damage to the occupied houses that they vehemently denied and said they were pre-existing conditions that had existed before. They left huge gaping holes in the walls and the exterior walls, cracks where water could enter the crawl spaces underneath the homes. They didn't even bother stuccoing the walls. They just left them exposed. And then they slapped black tar on them, which peeled off after it rained. It just made the neighborhood look like a bomb had dropped on it. So we could hardly be surprised that those families who perhaps were younger, more mobile, had more resources, decided they weren't going to stay on the sinking ship and they were going to leave. So in 2008, we were sort of forced with a dilemma. There was still about 150, 160 people households living in the gardens. We represented a whole bunch of them. They didn't want to leave and give up the fight. The state court litigation, we could have gone back and said, now our claims are ripe. Or we could go to federal court and emphasize our disparate impact claim. And, it was sort of a real toss-up, and we deliberated it, and we decided that the federal law at that time, Title VIII, was a more clear-cut claim. It seemed like we met the criteria of it more clearly, whereas our state law claims were a little more nebulous and a little more things we were sort of trying to piece together but didn't have clear established precedent. So we filed in federal court, and we asked for an injunction to stop them from implementing the plan, and we didn't get it. And we got a judge who was very unsympathetic to our claims. The defendants kept filing motions to dismiss. We lost a few of our claims for motions to dismiss, but basically the judge sat on the claims for a very long time before deciding them. Finally, after about 2 years of the case languishing in court and the township continuing all this destructive activity to pressure people to move out, the judge converted the last motion to dismiss into a summary judgment motion, even though we had had no formal discovery in the case whatsoever, and granted them summary judgment, basically just really conflating what's a disparate impact claim and what's an intentional claim. The crux of the judge's ruling, it was that the township didn't treat white Gardens residents any differently than it treated African American and Latino Gardens residents, so there couldn't be discrimination. So we appealed that to the Third Circuit, not knowing what to expect, feeling the judge was really wrong on the law, but also recognizing that Title VIII Fair Housing Act was coming under increasing attack, mostly due to the fact that it had been used against the major banks in predatory lending. That really got the insurance and banking industry very upset about disparate impact. And generally the more conservative turn of the federal courts and a more conservative Supreme Court made them feel like this was their chance to get rid of disparate impact. So there was a real organized campaign against disparate impact. Well, we went to the Third Circuit and we drew a really wonderful panel. And the first thing we got from the Third Circuit was a stay of implementation of the plan. That was the first thing that gave us hope and gave the community hope. The second thing that happened was that we actually had argument and got a favorable decision from the Third Circuit, a really good decision that clearly affirmed what disparate impact was and why it was important and why we had proven a claim, we had stated a claim and remanded it for us to proceed on that claim. Well, the township, of course, appealed the case to the U.S. Supreme Court. And I am the only person I know who never dreamed the Supreme Court would take it. I think it's just because I just never thought I would end up in front of the U.S. Supreme Court. Just not on my radar screen. So I was just foolishly optimistic that, of course, they wouldn't take it. But the reality was that there had been a prior case which the Supreme Court had taken on a disparate impact claim that got settled like a few weeks before oral argument. And the Supreme Court had missed its chance to make that ruling. And apparently some members of the court were eager to have that issue come up again. There was some unbelievable number of amicus briefs filed for and against cert on our case. It just showed how much of an organized opposition there was to disparate impact and how much of the civil rights community was determined to do what it could to protect it. So all the major civil rights groups were involved. This is where the process, as I say, became a very surreal experience because everybody suddenly had an opinion in our case. While the gardens was being slowly destroyed, there weren't any groups that were interested in helping us. We had no allies except this right-wing libertarian group, the Institute for Justice, who hates eminent domain, who was, ironically enough, our only ally during that whole long 10-year struggle. But suddenly, we were the case on which disparate impact hinged. And everybody thought we should settle, we should drop it, we should dismiss it, we should do that, we should do this. The township was getting calls on its side, you have to do this, you have to do that. The Supreme Court did grant cert, and we hired, we retained, all of a sudden, all these lawyers, that's another surreal part of the experience. I found out there was an entire professional bar that does nothing but litigate Supreme Court cases. That's what they do for a living. And everybody wanted a chance to have our case for free. It didn't matter that all the predictions were that we were probably going to lose. They wanted another high-profile case to argue. So lawyers, partners in these law firms who probably charge like $800 an hour would respond to an email from me within minutes. It was so bizarre. Because they all wanted our case. We went down to Washington and interviewed 3 Supreme Court professional law firms. One of them was the person who runs SCOTUS blog, because they wanted a chance to argue our case. So we picked someone. We tried to work with them. We worked on the briefs and all that. Meanwhile, a lot of people wanted us to settle our case. And that's really what the Supreme Court taking cert did for us. There were organizations willing to fund money for the Mount Holly redevelopment if it was going to turn out to a positive result that we could live with. So suddenly, I didn't mention, the township had gotten itself $18 million in debt on this failed redevelopment project. It was losing money. It had major budget crises. And it had this war zone to show for its $18 million spent. So it too needed a way out of this. It too needed a path other than legal victory, which was still going to leave it in a financial disaster. So we started these negotiations that were moderated or facilitated by Kevin and Adam from Fair Share Housing, Kevin Walsh and Adam Gordon, who we would have never settled this case without them. They did an amazing job, just amazing, keeping us focused, keeping us talking to each other, keeping us, sane, and making us work really, really, really hard. And we had these tortured meetings, conference calls, endless meetings for 8-9 weeks. well, probably longer than that, probably like 3-4 months. We were just in these very hot negotiations. Our position was that people who wanted to sell their house and move, who had had enough, should be given a fair price that they could live with as a relocation package so that they felt comfortable moving where they wanted to go. And anybody who wanted to stay should be given an affordable house that they could live in that wouldn't cost them any more money than what they're currently paying now. It was very ideologically simple and pure. It was ridiculously hard to actually make it work. Because the reality is that when you tear down, even though it's not subsidized housing, but when you tear down housing that's affordable, that's cheap, that's more modest, it costs a fortune to replace it with something that someone of our client income level can afford. Not to mention things like they can't get mortgages, they can't pay higher taxes. I mean, we had to negotiate for every contingency, how to make sure their property taxes would be affordable, how to make sure that they would get financing to pay off their old mortgage and get a new mortgage, how their utility costs wouldn't go up, what would happen if the houses weren't built, what would happen if funding that was expected wouldn't come through. I mean, there was 1,000 contingencies. One of the best things that happened was that a new mayor and administration got elected in Mount Holly, and they were actually, unlike the old guard, they weren't invested in this project. This wasn't their project. And they wanted a way out of this mess. And they saw the money that these foundations and, organizations had raised to pay for the redevelopment as a way out of the financial hole that the prior administration had dug them into. So 3 weeks before oral argument, we settled the case with those essential terms. And we've been slowly implementing the settlement agreement ever since. Still a work in progress.